days. So it's nice to feel part of a very alive system that is part of insolvency in India. We've been asked to talk about Australia, and Jason and myself will share the slides, and what we hope to do, I think, is just flesh out some of the topics, and it might be a bit disjointed, but we can come back to things if not, as in answering to your questions. The first few slides I'll handle, and really just to observe that the Australian government reacted to COVID quite quickly, and put in sort of really quite an unusual system of both putting the states of Australia and the federal government together, and coming up with an approach. So these first few slides really just sort of summarise some of that approach that we've now see. I also thought it was probably worthwhile saying at the very outset that the Australian dollar is worth about 50.34 Indian rupee at the present time. So when I talk and Jason talks about dollar amounts, you might have to do that calculation yourself, or times by 50. So just to look, that first slide really is talking about the policy changes with regard mainly to the federal government's changes. Firstly, to tax, they really address the small and medium enterprises, and not so surprising, because I think that the figures suggest that there's about 97% of Australian businesses are small and medium enterprises. And also, I think a recent survey has indicated that 89% are having some impact being made upon them from COVID. So, these changes pretty much pitched at the small and medium enterprise end of town. So up to $100,000 in tax credits, really keeping tax withheld on behalf of employees was one policy. Another policy, the instant asset tax write-off, so looking at that sort of bad debt approach, and taking that to 150,000 Australian dollars. In a sense, really just trying to adjust what would be normally flowing through to government. It hasn't stopped the requirement to pay tax. It hasn't stopped the requirement to lodge business activity statements in the quarterly expectation that our businesses have. There's a government guarantee for 50% of small and medium enterprise loans in businesses with turnovers up to $50 million. And again, really just trying to help out that small and medium enterprise group of businesses in Australia with the government guarantee of their loans. Wage subsidies for apprentices and trainees obviously just help out the younger members of the employees in those companies, and some regional assistance, things like subsidising flights to regional areas. Again, Australia being a large country, those needs to get people able to keep working, etc. The unemployment benefits doubled, and certainly there has been some call for unemployment benefits in Australia to be much larger than what they have been, and so this has been almost a good thing for those who were unemployed beforehand and those being made unemployed by COVID, in that they are now getting a greater government handout. Linked to that was free childcare, and childcare in Australia is for certainly lots of young parents a very high expense item. So to ensure that people could continue at work, etc., free childcare was put in as a temporary measure, and wage subsidy to keep workers employed. We've got these two systems now called Job Keeper and Job Seeker. And the job keeper is one where workers maybe perhaps not going to work, but are being paid a job keeper allowance. Those that have lost their jobs would be then looking for job seeker. So there's just a word difference there, but both of those things will come to an end at the end of the COVID time. To the second slide, the Australian Tax Office is clearly tailoring solutions for company directors and business owners that are struggling with these temporary reductions of payments and with some withholding enforcement actions, such as we have these things in Australia called director penalty notices, which if the company's not paying its tax, the directors can be issued one of these director penalty notices. And also withholding applications to winding up companies. So the tax office is seen to be a very active player in the winding up of companies. They often have a percentage, almost a target of how many that they're needing to wind up in a particular quarter or a particular year, and what they're being told to do is to not proceed down that normal path of enforcement actions like that due to COVID. The government is also putting together services to guide businesses through the relief options that are available. The legislative changes which were brought in March were really quite rapid as far as legislative response goes. It took, I think, something in the order of 72 hours to get these through. Bipartisan was support from any of the opposition government, the opposition parties, and so we've had the Coronavirus Economic Response Package Omnibus Act, or Serpo is probably an easier way of saying that, and that was in March of 2020. It's going to apply for 6 months, and so we have a 25th of September 2020 is going to be the end of these interim measures. Because there was really no committee able to debate these things and not really an opposition to test them, it's appropriate that these changes are only for that 6 months. There is the potential for them to be extended beyond that time frame. I will just say some things about that later, but one of the problems I think we're going to have with 6 month periods is that people are going to know that 6 months is almost coming up, and behaviour is going to be perhaps altered just before that period of transition. So reforms, there's schedules to this legislation, and they're in place, and there's three major parts to the Serpo legislation. The Federal Treasurer has been granted power to amend the Corporations Act, which is our main act that deals with all sorts of corporate law, including corporate insolvency laws. So we don't have a separate piece of legislation for corporate insolvency law. It's all part of our Companies Act, called the Corporations Act. And the Treasurer has been sort of given almost dictatorial powers to change things in that Corporations Act, but only for this period of time. Our regulator is known as the Australian Securities and Investment Commission, or ASIC, and so it's got the under the direction of the Treasurer is modifying and granting relief. And we might get a chance to tell you about some of the things that have been happening in that space. To the next slide, and the major legislative reforms, I said there was really three parts. One of them being that power of the Treasurer to be able to change the Corporations Act. The other two parts to it are really the approach to the way that a person, being a corporate person or an individual person, can enter into into a formal insolvency. So we have a system of statutory demand for corporate insolvency in Australia. We have a statutory minimum, which is normally $2,000. And if a company is owing a creditor $2,000, a statutory demand can be issued against that creditor, and there's a 21-day period to comply or to come to some arrangement, such as to compromise that debt. So this $2,000 statutory minimum has increased to $20,000 for the period of the COVID for corporate insolvency law. The issue of personal bankruptcy in Australia is dealt with separately in a Bankruptcy Act, and that has a process where if a creditor is owed money by an individual debtor, a bankruptcy notice can be issued against that individual debtor. That needs to be supported by a judgment, and also the amount is $5,000 for a bankruptcy notice, and that has been increased during COVID to $20,000. Now, we in Australia also continue to run acts of bankruptcy, and again, I might say something about that later as far as reform goes, but the statutory demand or the bankruptcy notice serving fairly similar purposes, either for corporate or personal, but as you can see, the amounts have been increased up to $20,000. You might think it's a bit unusual that there's you can wind up a company for just $2,000. You can only put a person into bankruptcy for $5,000. That certainly has been something that's been talked about over the years, but has never been brought into line. They're into line at the present time. I notice, I think Aurelio has joined our conversation, and I think Aurelio was talking in Singapore that that amount for COVID has gone up to $100,000. So we perhaps haven't moved as far as Singapore as far as that amount of money goes. The time to respond to the statutory demand or the bankruptcy notice has been increased from 21 days out to 6 months, and so that takes us to the late September. Again, just perhaps whilst it is fresh in my mind, I see that there's a real issue of transition in that there's going to be creditors who are going to perhaps hold back on issuing statutory demands in early September, because if you issue it in early September, your debtor is going to get 6 months, whereas if you issued it in late September, your debtor is only going to get 21 days to comply. There is also temporary protection for individuals who want to put themselves into bankruptcy, and that what we would know as a declaration of intention to present a debtor's petition is now being referred to as a temporary debt protection. And normally you get 21 days of protection. You're now being given 6 months. There's no stay on enforcement of contractual rights, and these changes to the statutory demand regime don't affect the ability of a creditor to pursue the company through the courts to obtain a court order or a judgment for the amount owing. And in fact, I've heard that lawyers are really encouraging their clients to continue actions against debtors in the courts so that they actually finish with a judgment, and at the end of the 6 months period they'll be ripe and ready to issue the bankruptcy notice. In a statutory demand sense, you don't need to have a judgment debt to issue the statutory demand, but obviously if you did have one, it's a fairly straightforward process to show that the debt is owed. Jason, I think you were going to join us and talk about directors' duties, so perhaps I should pass on to you at this point.
Yeah, thanks very much, Chris, and thanks very much for inviting us to speak on this topic tonight. I often say to my students, it's a fantastic time to be studying insolvency, and the current pandemic has certainly makes that true again. There's so many reforms happening in so many different jurisdictions. I think one of the beneficial things to come out of this crisis is that it really forces us to think about what it is that we value most in our insolvency systems. And so we may well see some meaningful law reform come out of this process. And certainly in the context of Australia, where we haven't had a comprehensive insolvency reform that's really looked at how we better promote restructuring, how we set up appropriate transparency requirements, reporting requirements, how we evaluate the rights and responsibilities of creditors, and indeed the particular responsibilities of insolvency practitioners. We really haven't had that for some time. Most of the law reform in Australia over recent years has been administrative in nature or regulatory in nature in terms of increased supervision of insolvency practitioners. And so I think Australia could certainly learn something from the Indian experience in terms of actually stepping back and having a thorough investigation of what the modern economy needs in its insolvency system. So thinking particularly about the position of directors and their liability, Australia has had for decades now some of the world's harshest insolvent trading laws, and they basically operate so that if a company is insolvent and a director either suspects insolvency or a reasonable person, if they were in that position, would suspect insolvency, then the director can be personally liable for unsecured debts that are incurred from that point onwards. Now, there are a range of defences in the Act, but they're very difficult to prove. And about 2.5 years ago, the Federal Parliament passed amendments to the law to introduce a safe harbour against insolvent trading. And the safe harbour base, which is in section 588GA, the safe harbour is focused on taking one or more courses of action which are reasonably likely to lead to a better outcome for the company. Now, there's not a lot more guidance in the legislation than that. There are some relevant factors that the court can take into account in assessing whether or not the courses of conduct that the directors pursued were reasonably likely to lead to a better outcome for the company. And in doing so, the court will look at the degree to which the directors were properly informed. So particularly thinking about appropriate books and records, making sure that the directors are taking an active interest in monitoring what's going on in the company. So certainly no defence here for sleeping directors or directors who are just relying on other directors to do their job for them. What steps did the directors take to try and protect against misconduct, particularly around destroying books and records as the company approaches insolvency? And then did the directors develop or implement a pre-existing restructuring plan to try and improve the company's financial position? The ability to rely on advice is also something that's relevant, although I would just note that there's no requirement in the safe harbour for directors that they actually seek external advice. So for example, during the early stages of a restructuring of a company to try and improve its profitability, so what we might call an operational restructuring as opposed to a financial restructuring, in those early stages of an operational restructuring, it's common to bring in external expertise who can take on the role of a kind of chief restructuring officer, chief transformation officer, and if they formulated a plan to try and improve his financial position, then if the directors implement that plan in good faith, then that is certainly relevant for assessing whether they've complied with the safe harbour. Now, even though there is the protection of the safe harbour against personal liability for insolvent trading for directors, and I would just note this doesn't apply to officers, so Chief Executive Officer, Chief Financial Officer, it only applies to directors. Even though there's a safe harbour there was still some concerns with the pandemic that companies that basically had to shut their businesses overnight for an indefinite period of time, that this could lead to concerns of individual directors that they'd be exposing themselves to potentially very significant liability. If you think about retail businesses, for example, that have been some of the hardest hit, tourism businesses, aviation businesses, that potentially are going to be closed for 6 months or longer, there was some concern that they might be exposing themselves to very significant liability. And so the government introduced effectively an additional safe harbour to deal with the pandemic. And the effect of that additional safe harbour, which is now in section 588G(AAA), the effect of that new safe harbour is effectively to put on hold the operation of the insolvent trading provision. That is section 588G, liability for insolvent trading. So putting it on hold for 6 months, provided that the debts were incurred in the ordinary course of the company's business during the 6 months of the protection period starting at the end of March. So if we go back to some earlier insolvency cases in Australia and also in English insolvency law to look at how the courts have defined incurring debts or acting in the ordinary course of business, we would know that that would probably include debts that are incurred to try and grow the company's business during that time. So it's not limited to just doing what the company had always done. It can be debts incurred during the restructuring process. And of course, if we're thinking about restructuring a business from a financial perspective, if that's going to involve a layoff of significant amount of workers, then obviously that's going to be incurring further debts. And that, I would think, and I'm sure you'd agree with me, Chris, that would clearly come within the scope of the concept of the ordinary course of the company's business. So there's a lot of scope there for directors within that new safe harbour against insolvent trading in 588G(AAA). Now, even though there's a lot of protection there, in Australia, directors still face a significant of personal liability even outside of insolvent trading. And that is, directors have a range of statutory duties in addition to equitable duties and common law duties, and there's no safe harbour for those duties. So even if a director was incurring debts with the view that they would be protected by the new COVID safe harbour, if they were trying to restructure their business in a way perhaps that gave preference to a group of creditors to the detriment of another group of creditors, for example, entering into a restructuring arrangement which conferred security on some creditors and thereby removed the pool of assets from the general unsecured creditors, it's at least possible that the directors could be acting in breach of their general duties, not just insolvent trading. And there's no safe harbour for the general duties. Now, there was some discussion at the time that these reforms were being debated in late February that we should extend the safe harbour to the general duties, but the federal government was very adamant that that was not appropriate because it would be sending the wrong signal to directors that they could act in bad faith, that they could act negligently, and that was not something the government was prepared to do. So the general statutory and common law duties continue to operate, and of course in Australian law that includes a duty to consider creditor interests at least where the company is insolvent and probably whilst the company is approaching insolvency. So the Bell Group case that I've mentioned there in the slides, the trial decision in 2008, which has a very extensive discussion of this duty, and then the appeal decision in 2012. And one of the things that we can take from both of those cases, the trial decision and the appeal decision, is that at a minimum, directors have to be thinking about the different creditor groups. So if they're making a decision to restructure the company's operations, if that's likely to disadvantage one particular group of creditors or multiple groups of creditors, then directors at least, at a minimum, have to have consideration of the position of those creditors. So in the Bell case, the problem was that the directors were pretty much only thinking about the interests of the banks, and so that then resulted in a breach of their duties. And in that case, the liability being imposed on the banks under equitable accessorial liability. So the main point there is there's some protection in the time of COVID for directors against insolvent trading, but there's a lot of other liabilities that directors are still exposed to. So it's a limited safe harbour, but there's still a lot of potential liability under the general duties, even when the directors are trying to save the business by engaging in restructuring efforts. The reforms also don't protect third parties with respect to things like voidable transactions, so unfair preferences, uncommercial transactions, unfair loans, unreasonable director-related transactions. There's a broad range of voidable and void transactions under our Corporations Act, and none of these safe harbour provisions protect against that. On that earlier slide, I did make note of the new, relatively new, they've only come in a couple of months ago, creditor defeating dispositions, which were introduced by Parliament last year and commenced earlier this year. And basically those provisions provide that if you are disposing of an asset of the company at less than market value, then it might be classified as a creditor defeating disposition. Now you might say, well, isn't that what uncommercial transactions are for? Isn't that what certain common law rules against improper dispositions are for? And I would say absolutely. What the government has tried to achieve here is to broaden the scope of liability by then using the finding that a transaction involves a creditor defeating disposition to then incur personal liability on the officers of the company who were involved in authorising the company to engage in that transaction. And furthermore, for third-party advisors, which could include lawyers, could include accountants, turnaround managers, who are advocating or promoting such creditor defeating dispositions, that they can be personally liable both in civil law but also in criminal law. And there's very, very difficult defences to establish to avoid that personal liability. So I think when we're assessing the Australian position for the protection of directors during the pandemic, we just need to bear in mind that it's really very narrow. It's only applying to insolvent trading, and when directors are running the business, trying to restructure it, trying to save it, there's certainly a lot of personal liability that is sitting there for the directors. So I might hand back to Chris.
Thanks, Jason. So the next couple of slides here, I've just asked the question, do the changes mean directors have immunity? And Jason was talking there about that safe harbour, and I was listening to some people talk about who were credit managers recently, and they were saying, well, the safe harbour changes seem to suggest a message to directors: please trade insolvent. But they were saying there doesn't seem to be a follow-up that says please supply credit to a message given to the creditors. So I suppose it depends on which angle you look at this one from. So as the next slide suggests, directors are not permitted to cause the company to incur debts outside the ordinary course of business, and should not seek to improperly use the temporary protection to gain advantage for themselves or someone else not connected to the company's usual operations. So there'll be this what is in the usual course of business, and what's the ordinary course of business, and that may well be the subject of litigation as we go past the COVID and we look back at what directors have been doing. Directors should avoid incurring debts for the purpose of speculative business opportunities, and that's really where those temporary measures that have been brought in that Jason's already mentioned in section 588 GAAA. I've mentioned about the intention to put yourself into bankruptcy, that's been extended out now to 6 months. interesting then is, well, what is the situation in Australia as we sit now at the end of May? And recent figures have been released that suggest that the bankruptcy numbers, that's personal bankruptcy, is running at about the same level as we were in 1990. So we don't have at this point any great spike in numbers of personal bankruptcy. But of course, that perhaps makes sense because for debtors petitions, people don't have to, they can indicate that they're going to go bankrupt, but they don't have to do that for 6 months. And creditors can issue bankruptcy notices, which also don't have to be complied with for 6 months. So whilst there may well be a lot of informal discussion going on about a person's insolvency, it's not reflected in formal appointments in the bankruptcy area. In the corporate insolvency area, it's true also that there's not spikes happening at the present time, but there's going to be, as we'd expect, a lag time also with corporate insolvency, particularly with regard to that statutory demand being pushed out to 6 months. The voluntary administration is our corporate rescue approach in Australia, and it was one that was introduced in 1993. We saw a very popular, it was picked up and adopted and quite popular in around about the turn of the century. Jason's been doing some detailed work on voluntary administration, but I think it's fair to say in 2020 there's a bit of an existing trend upward with regard to voluntary administration. And the slide here says, well, perhaps the appointment of administrators gives the company the ability to potentially avoid having critical supply contracts terminated for reasons only that the company's insolvency, thanks to the 2018 ipso facto legal reforms. And I think that in addition to the safe harbour that Jason was addressing, where we did make some changes back in 2018 with regard to ipso facto, it probably helps us a little bit now as we deal with COVID. Do we have enough registered trustees to deal with increased bankruptcy, and do we have enough registered liquidators to deal with corporate insolvency? Again, there's been regulation introduced to address the regulation of both registered trustees and registered liquidators in recent years in Australia, and that has seen a bit of a flushing out or a bit of encouragement of some registered trustees and registered liquidators to give up their registration because they hadn't been doing many in the past. So at this point, our numbers of licensed practitioners, if I could use that term, is not as high as it was 3 or 4 years ago. And so if there is going to be a lot of increased work, do we have the capability to deal with it? I was talking to the regulator this week, and I know that there are several applications new applications from around Australia for people to become registered liquidators. But I think the other thing that we've noticed in Australia is that some of the larger insolvency practices don't need everybody on their staff or their seniors to be registered. That a registered liquidator or a registered trustee might be a couple of the partners, but senior managers, etc. They're in good number, and I'm sure that we'll be able to cope with the increased activity.
Chris, can I just make a comment about that?
Yep.
One of the things that I think is going to be very interesting to watch in Australia with the decline in the number of registered liquidators is how insolvency firms respond to that in terms of their promotion policies. Because I know at least one major insolvency firm has a policy that it's only after you get your registered liquidator ticket that you're able to be eligible to be a partner. And so if we're finding then that fewer and fewer liquidators are getting registered, I do wonder what's going to happen in terms of gender diversity in the partnership ranks of our large insolvency firms. So that's something to keep an eye on.
Thanks, Jason. So perhaps just moving to a couple of other points, and then I know we're quite keen to get to our last slide, which really will open up a bit of a discussion between both of us about where we see the future is headed. So just some options for debt restructuring. In Australia, after a voluntary administration, it's possible for a company to enter into a deed of company arrangement. And there's been over the last perhaps decade a movement to put companies into these deeds of company arrangement. You can see the slide there refers to it as a DOCA, D-O-C-A. Put them into the deed, but in a sense use that deed as a holding DOCA, putting not necessarily putting together a restructuring plan, but more of just perhaps a way of holding it off to one side, which might offer in a COVID type situation a better outcome than seeing that the company really can't continue and must go down the path of winding up. So it's there is, I think, a potential for that holding DOCA. It's not really a piece of legislation. It's really more of a practice. That could we could see a bit more of that that provides a platform for keeping the company going. The other point on that slide, a temporary extension of the convening period to applying to voluntary administrations. Voluntary administrations in Australia are really, once the administrator is appointed, there's a very tight time frame to hold essentially two meetings, the second meeting being a watershed meeting of whether the company is going to enter into a reconstruction plan such as a DOCA or whether it's going to be liquidated. And that tight turnaround is one of essentially a month. And so often practitioners need to go to court to seek an extension of time. And we wonder whether there's not something that perhaps needs to be looked at there, that if there is an increase in voluntary administrations, that there also could be something of a greater period of time to get one of these rescues put together that potentially enable companies to avoid entering into liquidation prematurely without having the opportunity to get their business a chance to survive. Commercial leases is something that the government has recognised very early on in COVID, that it's going to affect a lot of the SME, but really it's probably going to be affecting even the large end of town as well, with regard to being able to meet commercial rents during such a period where there's inactivity. Australia is the federation, so we have 6 states and 2 territories, and then we have the federal government. And commercial leases is something which each of the state governments has as legislation. The federal government doesn't have power over commercial leases. So state-based law has seen the national the National Council, which is made up of the federal government and the state governments and territory premiers or chief ministers, and they put together a national code of conduct for essential rental of commercial rental. And it hasn't been adopted universally. There's there's different states have approached it differently. I've given an example of the South Australian Act there. There was an early act in March, followed up by an Amendment Act in April. And essentially the task was really to have a bias towards mediation in this area, to get landlords and tenants to sit down and negotiate in good faith, to sort of have this period up until the end of September of negotiating what their lease should deal with. So there's no one deferment of the process. The requirement applies to all commercial leases, whether the tenant is being affected by COVID or not, and they use the term affected lessee, which is essentially a tenant suffering hardship with a turnover of less than 50 million. And again, you can see that it's pitched towards the small and medium enterprises, but very much about getting landlord and tenant to sit down and talk, and then if that doesn't happen, if that doesn't resolve the issue, then going off to a small business commissioner for mediation. And if mediation with that small business commissioner fails, then going off to the lowest courts in the state, the Magistrates Court in South Australia, for a resolution. So if we sort of look at what Australia has done over the last 30 to 40 years, we've moved corporate law to being a federal law. We've moved consumer and competition law to being a federal law. We haven't moved commercial leases to being federal law, and now we're seeing in our response to COVID some difficulties, I think, because we don't have a federal approach, a national approach to commercial leases. Jason mentioned a matter of avoidable transactions and particularly preferences, and I would just like to perhaps say something about that before we go to our slides, our final slide, and that is that we have that law about unfair preferences, that we need a creditor and a debtor, and that we have is the creditor being preferred, is the creditor getting more than what they would if they weren't paid and they were to wait for the distribution from the liquidation. The usual defence to an unfair preference is to have no reason to suspect insolvency, or a reasonable person would not have suspected insolvency. And again, that sort of usual defence is probably going to be struck out a little bit by COVID. It's unlikely that any creditor could use that to say that they weren't suspecting insolvency of their debtor. The liquidators, I suspect, down the track will have great opportunity to pursue these unfair preferences, and it's been interesting to see how perhaps credit management has responded to this. Credit management bodies. I looked at the Institute of Credit Management today, and they were suggesting, well, what can creditors do? They could create a charge and have it registered under our personal property securities register. They could get more guarantees from directors. They could move to cash only supply of goods and services. They could send out more regular invoices, and that way they could perhaps avoid a liquidator later on chasing them because their unfair preference would be of a smaller amount, and they could introduce liens. I think that's just a really interesting sort of drilling down of how people are responding to COVID in Australia, is that they're trying to see what's the existing law, how that existing law might be used by people in the future when they're looking back at the behaviour of the company or the creditor, and then what they're approaching, how they're changing that. And so then to future challenges, and Jason, do you want to kick off the first of those?
Yeah, sure. So I guess the biggest challenge that we're facing in Australia at the moment, and we're all wondering how this is going to play out, is how is the government going to remove the incredible financial support that it's been providing, literally several $100 billion, things like free childcare and doubling unemployment benefits. That's unsustainable in even the medium term. But there's been a lot of discussion in Australia over the last couple of weeks about the need for the government to perhaps taper off the levels of support rather than simply end the support at the end of September, because it seems very clear that there are a number of businesses in Australia which are only remaining operating because they are receiving government support to pay their employees. So when that support ends, it's quite likely we will see a significant increase in unemployment numbers and a significant increase in the numbers of people going bankrupt and companies filing for liquidation. So that's a big challenge, and I'm certainly glad I'm not working in the government, because that's a very difficult challenge. How do you try and provide a soft landing for the economy so that people aren't literally thrown out onto the street? As Chris has been talking about with respect to the changes to leasing laws or leasing arrangements, that's a big area, because there will be a lot of landlords who will be starved of cash over the next few months, who will be looking to recoup some of those amounts. The guidelines that have been introduced, certainly for residential tenancies, don't mandate rental waivers, but rather allow for rental deferrals. And so again, it's going to be very interesting to see how the government, both state and federal level, manage the soft landing of these very extensive support mechanisms. So we're likely to see a very significant increase in defaulting debts, particularly once the major banks start winding back the flexibility that they're currently providing mortgage holders, and they're currently providing small and medium business loan customers. Once they start requiring more interest payments and enforcing loans, we're likely to see an increase in formal insolvency appointments and business closures. So that's going to be very tricky. We're fortunate in Australia that our very large banks are by and large very well capitalised, and so there is a significant buffer there. We've seen many of our banks, not all of them, but many of them have deferred paying dividends to shareholders, which is very unusual in Australia. Many people invest in bank shares. Sorry for the noise there. Many people invest in bank shares because they're known to have very high dividends. So the banks have a lot of dry powder that they can use to address these problems, but it's going to be interesting from a corporate law perspective how the banks and other large corporates are going to manage and balance the interests of shareholders who at some point are going to get dividends versus the interests of customers who might be really struggling. As Chris noted earlier in his presentation, the numbers of insolvency practitioners are decreasing in Australia for different reasons, and I think that's going to be a big challenge, and probably not this year, but probably by the second quarter of next year, I think we're really going to be struggling quite likely at the personal insolvency level, because the vast majority of personal bankruptcy cases, so not corporate insolvencies, but personal insolvency cases in Australia, are actually run by the government. And we're typically anywhere between 15 and 22,000 personal bankruptcies each year, and then about another 10 or 12 formal arrangements under our Bankruptcy Act, something called a Part 9. If we go up to 30, 40, 50,000 bankruptcies, which I don't think we've ever had in Australia, but it's quite possible in the context of most likely more than 1 million Australians out of work, I think that's going to put a very significant resource constraint on the government department that handles those bankruptcy matters. So that's going to be a great big challenge. In terms of the lack of funding and resources to support proper administrations, what that's referring to is one of the dangers of the approach that we've taken is to effectively 6-month hibernation period for businesses through various channels, through the measures that we talked about earlier in terms of the formal legislative changes, but in addition, the informal measures in terms of pushing back on the tax enforcement and also the banks giving far greater flexibility. One of the concerns is that there will be many businesses that really are struggling, and they're going to use that financial support and basically trade on almost into oblivion, so that there'll be far less left of those businesses at the end of 6 months than if perhaps they'd just gone into insolvency now. There's no doubt that many of those businesses were probably struggling financially before the COVID, and so this has just given them a further 6 months to really run down their assets. And we're likely to see a high number of companies that need to be placed into insolvency, but are literally too poor to go broke. They don't have enough assets to pay liquidators to do the job properly. So that's going to be a big challenge. Will we see the tax office taking more enforcement action in the public interest? I'm sceptical. Will we see ASIC, the Securities Commission, funding more insolvency cases? I'm even more sceptical of that. How will anti-Phoenix laws be used? So this is referring to those recent laws that were introduced, the creditor defeating disposition rules. It's going to be really interesting to see if they're applied to restructuring attempts. Now, I think many of us can look at a transaction and see where there is obvious improper purposes, directors trying to pay themselves, or creditors trying to buy up assets on the cheap for far less than market value. But it will be very interesting to see if the Securities Commission uses its new powers after directors and to go after insolvency practitioners who are assisting with some of these transactions. Chris has already mentioned that.
Jason.
Yes.
Jason, can I chime in there and talk about a little bit about zombie companies too, because I think there's a sort of a nice relationship there. Is that I've seen it suggested that let me just go back a step and say, well, what's a zombie company? I think that it's very easy to start a company these days in Australia. You can sort of basically do it online, and by the end of the conversation tonight, we could have a company already up and running. But it's then that there seems to be a lot of companies that are just zombie, in the sense that they're not active in any way. Suggestion has been that perhaps there might be a temptation for some in the community to use these zombie companies to increase their use in that they incur some debt, but they really don't have any assets, and that they're going to avoid paying creditors, but then they're not going to be tracked down. And in a sense, that's not phoenixing or anti-phoenixing laws being breached there, but it's just I personally think that there's potentially something in the order of over 200,000 zombie companies in Australia that are just not active, but are not wound up either. Jason?
Yeah, no, I totally agree with that, Chris. And in addition to that, the numbers of companies that are simply deregistered each year. So thinking about it from an insolvency practitioner's perspective, in Australia we have anything up to 150,000 companies that are simply deregistered each year, not necessarily with an insolvency practitioner taking it through a winding up process. So the incidence of zombie companies in there is certainly a concern, and that's something that I think you're right has really gotten lost in the anti-Phoenix drive that we've seen over the last few years, which is really looking at shifting assets prior to insolvency and starting up new enterprises. But what about the companies that are really the zombie companies out there that probably should be put in liquidation but aren't, either because there's no will or more often because there's no money to do so? On that last point there, will the pandemic spur broader insolvency reforms? And I note that Aurelio also asked that as a question in the chat box. Look, I would like to say yes, but I'm a realist and I don't think it will. Just to paint a picture of kind of the scene in Australia, there really isn't much of a political will or political capital to reform insolvency law in Australia. We have no champion in the federal parliament who's who's pushing for improved laws or more effective laws, or laws that will promote more corporate restructuring and corporate rescue. So at present, I would say my own opinion is I'm doubtful that we're going to see meaningful, significant reform. And I think at the end of the 6 months, we'll just see these measures removed. Now, that's separate from the financial support that I talked about earlier, but the temporary changes to insolvent trading and the like, I think they will just be removed. However, if we think about the economic situation, and if it really is as bad as it could be, then that may well provide the political will to actually have a meaningful look at Australia's insolvency laws with a view to providing a more efficient and a more effective regime, because our current regime is incredibly expensive and the vast majority of cases involve no returns to creditors or negligible returns to creditors. So if we end up with 100,000 companies going into liquidation, then maybe that will provide the political will to actually try and improve the law, as opposed to just increasing the layers of regulation that we're imposing on insolvency practitioners.
I think we are getting some sort of small reform happening just because COVID has happened. For instance, we're obviously more able now to. We were already doing some online meetings, but now, COVID has really suggested, oh well, we can hold meetings online, we can issue notices online, we can vote online, and we can do that. We can hold our annual general meetings in this period all online. So therefore we bring that into corporate insolvency law. We think, well, we can do a lot of those things now online. I know just recently I was talking to a barrister who's been doing examinations of directors under the corporate insolvency law, and there's also a provision under the Bankruptcy Act to do a public examination of bankrupts. That's being conducted online, and that perhaps that we can move further down that track even though COVID goes away. So we perhaps see a bit more of that. For instance, courts, I think, have sort of done well so far in Australia in this area, and I know that for instance, under Commonwealth law, you can't have in a criminal matter, you have to have a jury. So no juries have been possible during the COVID. Now that means that judges have been hearing matters that they can, judges by judge alone, but a whole host of offences under Commonwealth law that are not being able to be dealt with because there's no juries. Now, it seems to me that that's sort of something which might be looked at, which might not have been looked at had there not been COVID. So, potentially we're going to see sort of some small things. I think I was listening to something recently where I think it might have been Scott Atkins from Insol, Vice President, was talking about an Australia and New Zealand cross-border case where the judge in Australia and a judge in New Zealand are going to jointly hear the matter. They're doing it because COVID's pushed them to do this, but perhaps that is also a way of the future. Jason?
Yes, no, I totally agree with that, Chris. I think while I'm sceptical of reforms to insolvency laws, I think we will see a modernisation of civil litigation practices and court processes, and to the extent that makes things more efficient and helps to increase the speed and effectiveness of dispute resolution with respect to insolvency cases, then obviously I'm all for it. That's a good thing. Being able to do quick video hearings and directions rather than having to spend the day waiting to get your court slot could reduce costs for clients, which in an insolvency context is critical, given that the assets of the insolvent company or individual are a bit like a melting ice cube.
Even things, Jason, like getting signatures on things. Now that there's COVID, we've got these indicating a person's intention to sign rather than their signature. Is able to be done on company documents, electronic documents. That wouldn't have been thought of before COVID, and maybe past COVID, we might be able to get even some of that thing, those matters, much more 21st century.
Yeah, totally agree. Now,
Dr. Neeti?
Yep, we had some questions, didn't we, in the chat box?
Yeah. So we do have questions here. The longest one that appears is from Professor Rello, but I think you have answered. Professor Rello, would you like to speak it out in the mic and ask, or should I read it? Professor Rello has asked a question that COVID-19 crisis is making us think twice about design and functioning for insolvency systems. Some countries adopting pre-insolvency tools frameworks as a response to the COVID-19 crisis, and other countries traditionally imposing duties to file for bankruptcy or subordinating shareholders' loans are suspending these rules. Wrongful trading provisions are being relaxed or suspended in many countries. Other jurisdictions are implementing a type of debtor in possession regime in times of crisis. And some countries are adopting or thinking about the idea of adopting special rules for micro and small companies. Professor Rello would like to know your views about which temporary reforms might end up becoming permanent reforms, in particular in context of Australia. And do you think that the current situation or reforms in Australia or elsewhere will lead or should lead to any future permanent insolvency reforms in Australia?
I think it should, but I don't think it will.
That was a very short answer to the long question.
The problem is there's just no votes in it. The public has very little sympathy for the insolvency profession or for directors of insolvent companies. There is an overwhelming view in Australia that if a company goes insolvent, then someone's to blame, the directors must be crooks, and therefore someone should be punished. And so there's just no votes. There's no political capital in trying to make insolvency processes more flexible or faster, to the extent that it's going to reduce transparency and accountability and a sense of kind of almost retribution against those who've been in charge or benefited from the company that's gone insolvent. So that's where Australia is very different from North American jurisdictions, which we might say are more debtor-friendly than they are creditor-friendly. In Australia, it's the opposite. So we should be learning from what the Singaporeans are doing. We should be learning from what the Indians are doing, even what the New Zealanders are doing, but we don't.
I suppose my response is I think that there's always fine balances in insolvency. Jason's just mentioned pro-creditor, pro-debtor, maybe pro-regulator, pro-insolvency practitioner, but so all of those fine balances, but I'm reminded of a picnic I went to once with an insolvency lawyer, and I asked him how business was going, and he said we could do with a recession. I think maybe we've got the recession now or whatever, and so maybe we will see something come of all of this because everyone's talking about it. But I agree with Jason. There really is generally very little in it from a votes point of view. So we don't have in a very large Australian Parliament. We don't have we don't have a corner to box from, really.
Very interesting. Rinal wants to know what happens to the debts that have defaulted prior to the COVID disruptions. Is all defaulted debts, COVID-related or otherwise, subject to 6 months statutory demands?
No. So the statutory demand process is only one way to assist in winding up a company. So in order to get a winding up order from the court to put a company into liquidation, you need to have some evidence that the company is insolvent, and having non-compliance with a statutory demand is an easy way to establish that evidence. So if you have a debt, whether it's a COVID-related debt or a non-COVID-related debt, you're able to continue with court proceedings to enforce that debt. You can then use the non-payment of that judgment debt as evidence to support your liquidation application on the basis that the company is insolvent.
He has a following question. Professor Symes, would you like to go ahead? Or
No. I was just thinking about the transition. If there was a statutory demand issued and the 21 days was running before the 25th of March, that would be the 21 days would still count. If it was a statutory demand that was issued after the 25th of March, it would be for a 6-month period.
Right. Here's the following question. Would lenders holding defaulted debt before the COVID disruptions be looking to or are really forced to restructure to protect their returns? Or are they waiting till 21 days period to be restored before launching an insolvency process?
Lenders is a big group. I think if we were talking about and we're really talking about unsecured creditors rather than secured creditors, I think the secured creditors are not going to be thinking along those lines. And then when we sort of get into unsecured creditors, we've got different mindsets. We've got some unsecured creditors that may well be going, we must collect all our debts. We must do it as efficiently as possible. This is a great opportunity to chase down bad debts. Let's go hard against our debtors. And then there's going to be a lot of others who are going to sort of think it's a bit of a domino, isn't it? If we push hard on our debtors, some of our creditors might push hard on us. I'm not sure that we could generalise.
Yeah. Preeti from Australia has joined. She wants to know, could holding DOCA become the trend in the days to come in Australian insolvency in the new normal period as well as post-COVID situation? And she has a following question. How do you see the future from here? Would this mean spurring court litigation as well once mediation fails?
So I think the answer, if I deal with the second question first, I think yes. The guidelines, the national guidelines with respect to leases are so broad and have been instituted in very inconsistent ways, as Chris said earlier, that I think we're guaranteed to have litigation. There's a lot of very cranky landlords and a lot of very cranky tenants out there. So we're bound to see more litigation on that. So I think the answer to that is yes. Will holding dockers become the trend? Yes, I think that's right. I'm not sure whether that's tied to COVID or not, though. It's a very flexible tool that can be used to just give the docker administrator more time, the insolvency practitioner, to try and achieve a better outcome. Now, if we're in the middle of a deep recession, then maybe that's not the best time to be trying to sell businesses. So entering into a holding docker for 1 year or 2 years to just keep the business going, that probably makes a lot of commercial sense.
And that's a very big point, the idea that really, is there a market at the present time? If a liquidator or an administrator is really trying to sell part of the business, who's out there looking at buying it at this point?
Xenia, you have raised your hands. Do you have any question? Okay, I think that's all that we had for today.
So
if you have any questions,
there was more question there. Chetan, number 2, asked a question at the start of the discussion, and there's quite a quick answer to that. So the question was, is there a separate regime for bankruptcy in the case of individuals as the Corporations Act for companies? And the answer to that is yes. We have totally separate laws in Australia and totally separate regulators. even though they're both federal forms of law rather than state-based law. Sorry.
And I guess that's the Bankruptcy Act 1966, right, Professor Jason?
That's right.
So, so thank you so much for your valuable time, and I think it was a great session. Professor Rello has also expressed his thanks to you for your answers. And would you like to give any concluding remark before we close the session, Professor Jason, Professor Symes?
Dr. Needy, I think both Jason and I have enjoyed doing it, and if you would like to invite us again, we would like to say yes again.
Absolutely. Sorry.
I think it was truly a delight to have both of you with us today. And, you know, we can't thank you enough for your valuable time. And despite the time difference between Australia and India, you agreed to do the session for our viewers. Thank you so much, Professor Symes, Professor Harris. You know, the discussions like this add to the larger debate that's happening in India. And, you know, I must know that your valuable efforts are helping us sort of strengthen the debate in our own country. Thank you so much for this. I also would like to thank our viewers who have been very patient. We have, you know, we intentionally timed the sessions to be 1 hour, but each time, you know, the debate and the discussions are so engaging that we always cross the time. And but the viewers have still shown their patience. Thank you so much. The recording of this session will be available on our YouTube channel. Please tune into that. And I also would like to thank our IT, Mr. Abhijit Chakrabarti. You know, he single-handedly, you know, is handling all these webinars. And the real force behind the Friday talks, which is Urvashi Shahi, who's a senior research fellow with the center. Thanks to all of you, and do join us next Friday for the new talk. We have Mr. Paul Omar, Professor Paul Omar, joining next Friday. Professor Harris and Professor Symes, last question has just popped in the box. If you would like to just take it, so that we don't daunt the viewer.
So, will the suspension of insolvency law help the economy? Is that the question?
Yes. So,
yeah.
Could I just respond? I talked a little bit about unfair preferences just as part of the voidable transactions, antecedent transactions really area. There is a push by the Australian Institute of Credit Management to actually suspend all preferences. So that would be a real suspension of insolvency. I don't think we've got a suspension of insolvency happening quite. We've got a suspension of perhaps the duty to not to trade whilst insolvent. So you know, will it help the economy? As long as I think always insolvency is a fine balance, as I've already said, and we've pushed the balance in perhaps you know, a risky direction by letting directors be able to continue to trade if their company is insolvent. But you know, there's going to be some responsibility that they'll have to take, because they're going to really have to show that they're taking a course of action, which is one that they should be taking, for instance. So we probably haven't suspended insolvency, but is it helping the economy? Yes, you'd like to think it was, but we probably haven't done that yet.
Excuse me. Yeah, no, I totally agree with what Chris has said there.
So thank you so much, everyone, for your time, and special thanks to Professor Symes and Professor Jason. And we do look forward to having you again. Thank you.
Wonderful.
Thank you.
Thank you. Bye, everyone.